Hi, everybody. Welcome back to another week of Law, Politics, and Society. This week, we're going to be looking at civil and administrative law, and we're going to be diving into some really interesting concepts about property, contracts, and what happens when legal promises break down. So civil law is defined as the ability to provide remedies for individuals after they've been harmed by others. So the goal of civil law is to manage social conflict as well as restore social harmony. So it's a means by which disputes can be settled between private parties without the use of force. So civil law really replaces coming to blows with your ex-husband or your best friend over a piece of property that hasn't been returned, and instead you can use the law. Civil law has substantive and procedural law and precedent the same way that criminal law does, but it doesn't involve the government, typically. It can. You can sue the government, but it doesn't always involve the government like criminal cases do. Civil law can be clearly divided into four main categories: torts, property, contract, and family. And juvenile law also is kind of part of civil law as well, which we touched on in Chapter 8. Now, again, this is going to be a really brief overview. If you go on to law school, you will spend a whole semester on torts, property, contract, and family on their own. So you will understand that this is going to be a very quick overview. So in civil law, the complaint is filed by the plaintiff. So they're a private party looking for a remedy to a breach of some type, typically a breach of contract. And so they can get redress in the form of monetary damages, where they get compensated for something. You can have an injunction where somebody is forbidden from continuing to do something, or you can have specific performance where you require somebody to do something. But the penalty is not inflicted by the state. So a judge will decide what the penalty is, and then the other person is obliged to follow through. But there's no incarceration or punishment using the criminal system for civil law. You can file criminal and civil cases for the same act. The most famous is the O.J. Simpson case. So O.J. Simpson was acquitted of murder of his ex-wife, Nicole Simpson Brown, but was found liable for her death in a wrongful death lawsuit. And this is because the standard of proof is different in criminal law than it is in civil law. So you'll remember in criminal law, it's beyond a reasonable doubt standard, which is a very high standard. But in civil law, it's preponderance of the evidence. So more likely than not that the defendant committed the wrongful act. 51% standard. Sometimes we use a clear and convincing evidence standard for punitive damages, compensatory damages, or involuntary commitment. And those would be sort of like a 75% standard. In civil law, the burden of proof is initially on the plaintiff, but if a prima facie case is made, the burden shifts to the defendant. So this is very different than criminal law, where the prosecution always has the burden of proof. In civil law, it depends whether or not the initial case can be met. And really, some cases are beyond rebuttal. The facts can be self-evident that it was a completely negligent act, and it's not necessary to prove additional details. But it really depends on the case. And only about 6% of civil cases go before a jury. Most are settled long before they reach the trial phase. There's no exclusionary rule in civil law. There's no right to remain silent. There's a diminished right to cross-examine hostile witnesses. And there's no legal obligation for states to provide attorneys for indigent defendants. So you don't get the same sort of rights in civil law because you're not facing the same sort of jeopardy. Whereas in criminal law, you could be facing incarceration or in some states death. That is not true in civil law. And so there's a reason why the state does not pay for you to have an attorney for civil cases. Tort law is one of the biggest areas of civil law. We get the word tort from the Latin term tortus, which talks about a wrong. And so this is a body of law that's associated with a harm caused to a plaintiff by an action or inaction of the defendants. So this is not contract law. This is not dealing with contracts. It's dealing with harm that has been caused sometimes by companies, sometimes by medical malpractice, sometimes by paparazzi if they're invading your privacy. So it determines what type of harm has been done and what the appropriate remedy would be for that harm. And so the goal is to return the plaintiff to the position similar to how they were before the harm occurred. So the goal is to get them back to balance, which can be a really difficult thing because in wrongful death suits, you can't bring somebody back. And so you might be monetarily compensating them for a loss, but you can't bring people back from the dead. Damages awarded in tort law are typically monetary, and most lawyers that do civil law spend most of their time on torts. Torts are sort of the bread and butter of American civil cases. There's no double jeopardy that applies in civil and criminal torts. So this is where you get that O.J. Simpson case. But you can't bring the same suit against the same person for the same civil case. So you don't get to just keep bringing them back and back and back and back to court with some limitations. So in the vast majority of situations, you're not going to be able to keep bringing it up and up again. And this is because of res judicata, which is the thing decided. So it's already been decided. You can't keep bringing it up. If there's witness tampering or perjury or something that you can prove went horribly wrong, then that's very different. And then you could bring it again. So there are three main categories of tort. The first is an intentional act, and this is where the defendant deliberately caused harm to another person or their property. So this would be the O.J. Simpson type of case. He was responsible for Nicole Simpson Brown's death. Negligent acts are acts when the defendant has duties to act in a particular way, but they either breached that duty or failed to do the duty at all, and as a result, harm befell the plaintiff. And so this looks at a standard established, which is usually called the ordinary care standard, and this was decided in Lubitz v. Wells in 1955. And again, looks at those causation aspects, the factual and legal causation. So factual causation, that but-for test again, and then that legal causation, were they legally responsible, not just factually responsible for this issue. So the Lubitz case is actually an interesting one. It's using golf clubs, and the court in that case found that golf clubs are not such a reasonably dangerous item that people wouldn't leave one around in their own backyard. Things can happen if kiddos get a hold of them, but it's not grossly negligent to leave a golf club lying around. Now, this may not be the cases with, other objects like guns, for example. If you don't leave your gun properly stored and with the ammunition separate and something bad happens, it's possible that you would be subject to a tort. Strict liability torts are when the plaintiff need not prove the defendant acted intentionally or negligently, just that the act happened. So drunk driving is a strict liability. We talked about that in criminal law, where there's no responsibility to prove that you intended to drive drunk. It's just, are you drunk? Yes. Were you driving? Yes. This is typically used in cases of animals attacking people. You don't have to prove that the animal was subjectively dangerous. Just, is this your animal? Yes. And is this other person injured? Yes. So we've seen strict liability sort of evolve over the years, and we'll talk a little bit about more about strict liability a little bit later. So if you want to defend yourself against a tort, what options are available to you? Well, you can argue that you weren't the cause of the damage or that you didn't have a duty to a specific person. But typically there's three main affirmative defenses that people use: contributory negligence, comparative negligence, and consent and immunity. So contributory negligence is when you can prove that the injured party is partially responsible for their injuries. And if the injured party is partially responsible for their injuries, then they don't get to recover damages. So people don't get a free pass if they poke a bear and poke and poke and poke and poke and poke the bear, and then the bear reacts. So if you get into a bar fight and someone gets some teeth broken and then they sue you for medical bills, but it turns out that they were more responsible or just as responsible, they don't get to get their medical bills covered. Comparative negligence apportions responsibility. So it says you were 50% responsible, Bill over here was 50% responsible, so you can pay Bill 50% of his bill. Too many bills there, but his medical costs. So it apportions responsibility instead of being a winner-take-all. Consent and immunity, which is also sometimes called sovereign immunity, talks about the level of consent and who has the ability to sue and when. So, for example, judges cannot be sued for their judicial decisions. Most governments have sovereign immunity as well. So governments didn't used to be able to be sued by their citizens. Sometimes you can, but not in all circumstances. Probation officers performing their duties largely can't be sued. Sheriffs, bailiffs, police officers can, but it's a different threshold. And the consent defense looks at whether or not the person consented to receiving that type of harm. So we're talking about UFC, boxers, NHL players. What can people consent to? And what is reasonable to be able to consent to? And the courts have consistently held that people can't consent to their own death. And so there is a line. Tort reform is the attempt to have legislation passed to limit the number of lawsuits. In the United States, there have been several major headline cases. This is why I had you watch the McDonald's case. Many people think they're really familiar with it, but actually the facts are really different than the news media discussed. Tort reform was largely driven by headline cases. People thought that they knew what had happened in those cases, and they really didn't. And Americans in general have seemed to started to sue each other less, which is a good thing because the U.S. was number one in lawsuits for per capita, so even looking at population size, for decades. And it seems that this is starting to relax. But tort reform was looking to cap damages and change how much you would be able to recoup, even if you had really large medical bills or had suffered very severe damages. And so tort reform has happened for some medical malpractice, particularly in Texas. There's a great podcast called Dr. Death, if you're interested in it. It talks a lot about tort reform and medical profession, but it's something that constantly gets brought up whenever there appears to be a lawsuit where the judgment is disproportionate to the claim. Okay, so the next type of civil law is property law. And property law is originally part of the English common law, and it was the protection of an individual's ownership rights. And so property itself is the right of protection, the right of possession or ownership. And it includes real property, personal property, and intellectual property. And the case of Pearson v. Post from 1805 is one of the most ridiculous and fun cases because it shows how willing Americans were to sue about just about everything. And so Pearson v. Post is about a fox. And two people are chasing after a fox. Somebody gets the fox. The other person thinks they have the right to the fox. Right? So Pearson shot the fox and carried it away in full sight of Post after Post had been hunting this fox forever. And so the question was, who had control over the fox? At what point did the fox become somebody's property? And so the end decision was that Post did not have absolute control over the fox because he hadn't yet shot it. And so Pearson, coming in at the last minute and shooting the fox, however discourteous, did not violate any property rights. And so this is one of the first really big American property law cases, and it's so ridiculous that it's about a fox. The City of Oakland versus the Oakland Raiders. This is even more interesting now that Oakland has again lost its NFL team. Poor Oakland. So this was about the initial decision to move the team to Los Angeles a long time ago in the 1980s. The City of Oakland fought the move, arguing that the city had property interests in the team and that the owner couldn't just decide to move it. But the California Supreme Court determined that you couldn't allow cities to take ownership of businesses, and it would be completely unjust. So the Raiders moved to LA, and then they moved back to Oakland in 1995, and now they've moved again. So very ridiculous. Real property interests are also rights. So you have a right to your property interests, and there's lots of different types of property interest. The first is a freehold estate, and this is where you own a piece of property. It's a very specific piece of property, and the possession to that piece of property ends at your death. So once you've passed away, typically the interest in that real property is no longer yours, and it reverts to whoever owned it before, or it can be passed down to your next of kin. Fee simple absolute estate. Fee simple estate, possession ends at death. It can't be passed down. It goes back to whoever owned it before. Fee simple absolute estate, possession does not revert to the original owner at death and then can be passed down. Tenancy in common is when multiple parties own parts of property. So a husband and wife might own parts of property. You can have 3 siblings after their parents have died own property, and that's when they have tenancy in common. And once their sibling dies or their spouse dies, the right of survivorship in the property can be transferred to the other person. Some other property interests. Easements are when you give limited right to use a property for a very specific purpose. So I might own 100 acres of land and I don't want to farm it all. So I give a limited right to Joe for him to farm canola on 50 of those acres. He doesn't actually own the land. He's being leased it or eased it for a very specific purpose. Adverse possession generally only affects abandoned property, and it has to be abandoned by its original owner. But it's very easy to prevent an adverse possession claim. Just show up on your property frequently enough or maintain the property to the point where it doesn't appear abandoned. The nuisance doctrine surrounding real property provides that property owners don't have unlimited and unfettered discretion as to how to use their property. They have to keep it in a way that is reasonably safe. So they don't just get to do whatever they want. This can be extrapolated into the city. You can't have super loud parties at all hours of the day and night because there are some nuisance laws. You can't park cars all over your front lawn and have a house that is an eyesore or a hazard. I'm going to post a link now that I thought of this. There's a case going on in California about the Flintstones house and whether or not it's a nuisance right now. So that's super interesting. Personal property is any tangible items not connected to land, and they're anything that can be transferred permanently or temporarily to somebody else. So personal property, think about cars or cell phones, computers, backpacks, anything that can move. Bailment is when a person transfers a possession of an item to another person for a particular purpose with the understanding it will be returned. So this is a transfer of ownership, not possession, but it has very limited usage. So it involves, very specific requirements. So you can think of a laundromat, where a person transfers possessions of their items temporarily to get them cleaned, and then they understand it will be returned. So she doesn't give the the clothes away. She's transferring them for a very specific purpose. Contract law. So contracts are legally enforceable promises, and they need all 5 of the following elements to be valid. So there have to be at least 2 parties to a contract. You can't have a contract by yourself, but you can have contracts with multiple people. There just has to be at least 2. The parties to the contract must be capable of signing the contract. So they have to have legal capacity, which typically means that they can't be under the age of 18, they can't be subject to dementia or be cognitively impaired, can't be drunk, so have to be fulfilling the legal capacity requirements. They must agree to the terms of the contract in good faith, so they can't intend to scupper the contract when they first sign it. They can't be attempting to violate it right away. They have to assent to the requirements and agree to uphold their side of the contract. Contracts must have both promises and considerations. So I will give you 500 apples. That's the promise. In return for season tickets to the Packers. That's the consideration. It has to have both a promise and consideration. What are you giving and what are you getting? And so this is a legality requirement. It has to be stipulated. What you're giving and what you're getting have to be very clearly defined. And contracts can be either written or verbal. Most people think they have to be scribbled down on the back of a napkin to be valid, or they have to at least, have been a handshake. Not true. Verbal contracts are just as valid and just as enforceable. Breach of contract is when the terms of the contract are not met. So I deliver you all of the apples, and then you never give me those season tickets. Right? That's a breach of contract, and then that's when I can sue. The Uniform Commercial Code is what standardizes trade and contract practices among merchants and businesses, and has existed as sort of an extrapolation of the British law of sale. And so this created a more enforceable set of contracts and rules for businesses to follow, and really was brought out of existing common law. Okay, so you wrote in your test last week about marriage, but we're going to talk more about it as we talk about family law. So family is considered a basic institution in society, and the state is really the third party in every marriage. A marriage is a binding legal contract in which the state gets involved, and family law is largely designed to protect the institution and integrity of marriage. It hopes to be conciliatory rather than accusatory. So its goal is not to determine who was right or who was wrong, but to create an acceptable remedy. Family law focuses largely on entering into and the dissolution of marriage because it involves the state. And the license and requirements for marriage vary from state to state. Some you need a blood test and a waiting period. Some you need to prove that you're not related past a certain degree. Some you need a license a certain amount of time beforehand. But the vows must be made in the presence of someone legally permitted to acknowledge marriage. So that can be a justice of the peace, that can be a clergy person who's registered with the state, and your marriage vows must be witnessed. So they have to be at least the 2 people getting married, as well as the person adjudicating the service, and at least 2 more people. So who can marry whom? Well, this is a legal contract which carries rights and responsibilities for both parties, and so it means that certain requirements have to be met. The first is legal capacity. You can't have mental deficiencies that would render individuals unable to consent. So you can't get married while drunk. You can't get married if you are technically insane at the time. You can't get married if you're siblings or if you're parent's child. Cannot be closely related. Can't get married if you're already married to someone else. That's called bigamy. So there's laws against bigamy. You have to only marry one person at a time. And the Supreme Court has a really long, interesting history on marriage and who gets to marry whom. In Skinner in 1942, the Supreme Court talked about how marriage was a basic civil right. And this is something that eventually the gay marriage debate focused in on, was the basic civil right premise. And Loving v. Virginia is one of the most famous marriage cases because it was about interracial marriage, as Virginia had a ban on interracial marriage. And Richard Loving, who was white, and Mildred Jeter, who was black, were residents of Virginia but left the state to get married. And when they returned, they wanted their marriage to be upheld. And initially, they were arrested for violating Virginia's laws against interracial marriage. And they took the case all the way up to the Supreme Court. And the court ruled that the ban on interracial marriage was unconstitutional under the 14th Amendment. But none of these cases changed the core definition of marriage, initially between a man and a woman. So the road to same-sex marriage has been a very long one, and at the turn of the 21st century, there was no country that allowed for same-sex marriage. Netherlands was the first country to allow same-sex marriage in 2001. Canada was the fourth or fifth, I think, in 2005, and the United States was the 20th country to do so. So the road to success for same-sex marriage was exceptionally difficult because public opinion was slow to change. In 1996, there were only 27% of the surveyed population who thought that there should be same-sex marriage, but that had rose to 60% in 2015. And one of the biggest hurdles against getting same-sex marriage recognized was what was called DOMA, or the Defense of Marriage Act, which was a federal law passed under the Clinton administration in 1996. It was passed by Congress and stated that only couples who were of opposite sexes could be married. And this was consistent with the previous Supreme Court decisions. And this started to change in California in 2008 because California ruled, the California Supreme Court ruled that same-sex marriage was constitutional, which was a huge shift. But that same year, voters in the state passed Proposition 8, which repealed the laws that had allowed for gay marriage. And so this set up a showdown between California, the state, and the citizens, as well as opened a broader conversation nationwide. So in August 2009, there was a lawsuit that was dismissed, both on Prop 8 and DOMA, because the jurisdiction was not the federal court. They said it had to go through state courts. So there was basically starting over. So in February of 2012, the Federal Appeals Court struck down California's ban on gay marriage, the Proposition 8 decision. And a couple months later, in May, a 3-judge panel for the First Circuit unanimously declared the Defense of Marriage Act to be unconstitutional, which led to the United States v. Windsor decision in 2013, when the court struck down the pivotal section of DOMA, which was Section 3, which restricted the terms marriage and spouse to a heterosexual union, and said that that was unconstitutional under the Due Process Clause of the Fifth Amendment. But the case did not establish a constitutional right for same-sex marriage, but there was a clear indication that the court was trending in favor of abolishing restrictions on same-sex marriage. And then in Oberfeld v. Hodges in 2015, we get the 5-4 decision that ruled that homosexual marriages are constitutional and are legal in every state. So in this case, they looked at 2 main issues. They looked at whether or not the 14th Amendment required the state to license marriage between 2 people of the same sex. And did the 14th Amendment require the state to recognize marriage between 2 people of the same sex whose marriage was lawfully licensed and performed in another state? And the court said yes to both questions. Now, they didn't create a constitutional right to gay marriage, but they said banning gay marriage was unconstitutional. So they flipped the language. And this case had combined multiple plaintiffs and multiple states to create a nationwide allowance for gay marriage. Common law marriage is similar to traditional marriage, except it's through cohabitation instead of through marriage license. So couples cohabitate and act in every way as though they're married for a certain period of time and maintaining certain criteria. So they may share a residence, they may sleep in the same bed, they may engage in sexual relations, they may travel together, but they may have kids together, but they just never got a marriage license. Some states recognize common law marriage as the equivalent of marriage. 11 states allow for common law marriage. 39 states have abolished them because of the contractual issues that abide by common law marriages. So because common law marriage would be part of a contract, it would require that the parties understand that after a certain point of cohabitating, they are entering into the same level of union as a traditional marriage. And some states do not necessarily believe that individuals acknowledge that they become married after a certain period of time. So some states allow for common law marriage, some do not. Divorce and annulment. So what happens when you realize that this was not what you wanted? Well, divorce requires legal grounds, and there are two types, fault divorce and no fault divorce. So historically, you could only obtain a fault divorce prior to the 1970s. So if you wanted to get divorced, you had to prove that your spouse had committed adultery, cruelty, desertion, was insane, or was an alcoholic. And that changed in the 1970s when no-fault divorce was introduced. And no-fault divorce meant that there was no assumption that either party in the marriage had done something wrong, but that the marriage was just no longer working. And so you'll hear many people announce that they're now getting divorced because of irreconcilable differences, for example. That's a no-fault divorce. You're not saying that either party is responsible for it, just neither party wants to be in the marriage anymore. And every state now has no-fault divorce. Annulments are different than divorce. An annulment is a legal declaration that the requirements for the contract were not met. So the marriage technically never existed. It gets voided. And this can happen if you can prove that the person lied as to who they were when they got married, or you were drunk when the marriage took place, or somebody was already married, etc. The lack of legal consent for annulments is important. You can also get grounds for annulments for impotence. If you didn't know that somebody could not conceive prior to getting married, that's still grounds for annulment. Concealing a sexually transmitted disease and concealing pregnancy from a union with another person are also still grounds for an annulment. So what happens to your property? And if you had kids, what happens to custody? Well, the dissolution of a marriage requires determining who gets what out of the partnership. And the statutes vary by state, but typically there's two dominant types of splits: dual property model and an all property model. So the dual property model is what's followed by most states, and it's where the courts considered that property that is acquired during the marriage be split, and that the spouses can keep their previous assets that they had before they came into the marriage. So everything that you get while you're together is joint, but the stuff you had previous can be kept separate. All property, they just divide everything in half. And this used to be more common and is now more rare. Custody is typically based on the custodial status of the parents. So who wants custody, who's in the best position to look after children. In some cases, some people voluntarily relinquish their custody rights. In others, there's a fight over custody, but the state has to decide what's in the best interest of the child and put that first. Whether or not there will be child support allocated is also based on the custodial status as well as income, the costs of child rearing, and many other factors. And states have very complex formulas to determine whether or not somebody will have to pay child support or not. And this has changed significantly over time. because for a very long time mothers were primarily being given custody and fathers were considered to be breadwinners. Fathers were automatically paying child support. But this has started to shift in the last 15 years or so when joint custody has become more common. So administrative and corporate crime, these still fall under civil law. Administrative agencies typically lack criminal enforcement powers beyond assessing fines, but they can refer corporate crime and administrative crimes for criminal prosecution. So you can think of the BP oil spill as an example. You can think of Enron. You can think of Bernie Madoff, or who I like to think of frequently is the Wolf of Wall Street, Jordan Bedford. White-collar crimes typically are absent from the tally in the Uniform Crime Report because they get a separate report. It's the Financial Crimes Report. And this provides a separate account of white-collar crimes each year, but it's not as well read or well understood. Previously, few corporate crooks faced any meaningful sanctions. They would often be fined if they were caught, but even then, in order to prove that they were engaging in illegal activity, it took a lot to get a prosecution, and very few white-collar criminals will ever see the inside of a jail cell, which of course is very different from what we call street crime, or the crimes that we've discussed more thoroughly earlier in the semester. But there have been a few areas of change. The passing of the Sarbanes-Oxley Act, or the SOA of 2002, required that company chiefs personally vouch for their company's financial disclosures. This is to help limit insider trading, as well as to allow individuals to be responsible for the disclosures they put out and not to inflate or deflate the values of their holdings. The White Collar Crimes Penalty Enhancement Act also created new securities offenses with slightly enhanced penalties stemming from the Wall Street crash and the recession in 2008. I'm not going to focus too strongly on environmental justice, or administrative law in general, but I just want you to know that it has been a concern since the 1960s, and environmental justice is an ideal that is often very difficult to obtain. The environment is a hard thing to protect, particularly in a capitalist society where we value profit. And so the most effective laws have been passed since 1960. We got the National Environmental Policy Act of 1969, which created the EPA. We got the Clean Air Act of 1970 and the Clean Water Act of 1972. All three of those acts fall under the jurisdiction of the Environmental Protection Agency, or EPA, which is the largest regulatory agency in the United States and divides enforcement tasks into three main areas: civil enforcement, cleanup enforcement, and criminal enforcement. So if we think again about that BP oil spill, there was a lot of cleanup that needed to be organized and overseen, and that often is prioritized first before the civil enforcement or the criminal enforcement. And so it can take very long time before we see any prosecutions or civil remedies coming out of big environmental crimes. Most regulations allow for both civil and criminal enforcement, the same way that wrongful death can be prosecuted both criminally and civilly. And defendants are typically tried under those strict liability principles. So there have been two cases that have really set out that framework: Rylands v. Fletcher in 1868 and United States v. Wetzenhoff in 1994. And both of those set out a standard that said that you don't have to intentionally pollute the environment or intentionally create environmental destruction for you to be punished. The creation of environmental destruction is enough to hold you accountable. Finally, support for environmental laws has waxed and waned across presidential administrations. In the current presidential administration, it has not been a priority. The EPA has had a few different chiefs under the current president and has seen a number of regulations be cut back or changed. The Obama administration entered office with this greenest credentials, but they backtracked on many of their proposals after they entered the White House, though they did kill the Keystone Pipeline, which may yet come back under President Trump. George W. Bush was seen as worse on environmental issues, And it's interesting that the actual sort of most positive president on environmental issues was the Nixon administration, because he created the EPA and he was largely seen to have a positive role in the environment. So I hope you have a great week this week. I hope you enjoyed learning about civil law, and I'll be talking to you next week.